Hi and welcome back. Attorney Steve Vondran. We are going live today, testing out some new streaming software here, so bear with us. Hopefully we have a good feed. But we are talking breaking legal alert here. I talked about this yesterday. I'm going to talk about a case called Derek Andrew Inc. versus Poof Apparel. Poof Apparel. So this was a case about a copyright registration. It had to do with the Andrew company had this Twisted Heart clothing line, and they used this special heart tag that had a heart on it. So that was kind of their trademark and also their copyrighted image. And so what happened is Poof Company was a company that sold retail to stores such as TJ Maxx, Wet Seal, Marshalls. Now, meanwhile, keep in mind that Andrew Inc. was selling their product in Nordstrom Higher End, Saks Fifth Avenue, and Neiman Marcus. So what happened is the actual use of the mark for Andrew started in 2003. That was the first use, but they didn't register the copyright then. In fact, they didn't register the copyright until 2015. So a little bit, almost 2 years after they'd started using it. And then what happened is Poof Company apparently sold 189,000 garments that had a very similar tag, just with a different name. And so Andrew Inc. sued for copyright infringement and also for a violation of the Lanham Act that deals with trademark law. So at the end of the day, the judge awarded damages to the plaintiff, that's Andrew Inc., and I believe that was in the amount of $685,000. But that really wasn't the question in the case. The question in the case was whether the plaintiff would be entitled to attorney fees under copyright law. So what the trial court did was they awarded $15,000 in statutory damages for the copyright infringement, and also $296,000 in attorney fees. So that was quite a bit in attorney fees. So this case was brought up on appeal, and basically the defendant was arguing that because the copyright was not registered at the time that it was created or within 3 months of the first publication of the mark, that they were not able to recover attorney fees. And the court agreed. The plaintiff argued, well, Judge, there's this continuing infringement. It just keeps continuing. So, we since registered our trademark and the infringements keep continuing. The court said, no, we're going to look at the first act of infringement, and we're going to look at that date, and we're going to see, did you register your copyright at the time you created it? You fixed the tangible work in a tangible medium expression, a creative work in a tangible expression, or within 3 months of the first publication of that. If not, this court, and this is coming from the Ninth Circuit, United States Court of Appeals, Ninth Circuit, said, nope, sorry, you got to register your copyrights if you want to get those attorney fees and those statutory damages. So that's a big case for those of you that are fighting copyright trolls, legal movie download trolls, these companies that are coming at you saying, you got a photo on your website, I want $10,000. You need to ask them, do you have a registered copyright? When did you first start using this? When did you register your copyright? Let me see it. So this is a very important case. In this area, again, the citation is 528 Federal 3rd 696, Andrew Inc. versus Poof Apparel. Okay, general legal information only and not legal advice. Steve Vondran, civil litigation attorney. You can find us at attorneysteve.com. I hope this worked, and we'll see if this is going to work for us in the future. So if you liked it, give us a thumbs up. Let us know it looks good, it sounds good. If it's horrible, just say, Attorney Steve, go back to the other stuff you were doing. We like it better. So anyway, gotta run. Have a great day. We'll talk again.